Omugaga Lwasa Emmanuel.
Representing the state in this court. Your Honor, the accused is in court for pleading and we are ready to proceed with the application. Your Honor, the complainant is in the court.
Which language are you comfortable with? I'm going to read in English and my clerk will translate for you. You Lwasa Emmanuel Kawes, you're also known as Lwasa Akram. You're a male, aged 55 years, Uganda by tribe. You're a businessman and a resident of Nakabwosel, Ulenga Parish in Wakiso district. You were charged with 3 offenses. And the first one is obtaining money by false pretense, contrary to section 284 and 285 of the Penal Code Act. The allegations are that you, Lwasa Emmanuel Kawesi, also known as Lwasa Akram, on the 23rd day of September 2024, at Luanga Zone, Makindye Division in Kampala District, with intent to defraud, you obtained 21 million shillings from Basaji Robert by falsely pretending that you are going to sell to him a Toyota motor vehicle with a personalized number plate, Lwasa 4, with previous registration number of UPK 306E, whereas not.
Lwasa Emmanuel Kawesi Mukyala Lwasa Abraham emyaka 55 mu Uganda, oli musajja musuubuzi era obeera Nakabwose Bulenga Parish mu Wakiso district. Omusango ogusooka gwa kufuna ssente mu ngeri y'okukumpanya oba nkusa olukwesikwesi. Bagamba nti gwe Lwasa Emmanuel Kawesi ng'omalikiddwanga Lwasa Akram ennaku z'omwezi ali 23 omwezi gwa mwenda omwaka 2024 Luanga Zone Makindye Division mu Kampala District wafuna ssente emiliyoni 21 engeri y'omukujjukujju okuva eri Basaji Robert agamba nti ogenda muguza emmotoka Toyota ng'eriko namapleti eri mu mannya ga Lwasa 4 naye ng'enamapleti yaayo erina okusooka yali UPK 6 ekiri kutamu.
you respond?
oddamu ekintu
sibitegeera.
You don't understand, or how do you respond specifically?
Si bwe byali.
Plea of not guilty is entered on count 1.
koti wasiza omusango gusoose okusumibwetaano.
Count 2, you're charged with issuing a false check contrary to section 358 of the Penal Code Act, Cap 128. You, Lwasa Emmanuel, Kawes, also known as Lwasa Akram, on the 20th day of August 2025, at Rwanga Zone, Makindye Division in Kampala District, without reasonable excuse, you issued Equity Bank check number 00131 for 8 million shillings to a one Wasaji Robert, drawn on account number 3200494914, without reasonable grounds to believe there were sufficient funds in the account to pay the amount specified on the check within the normal course of banking business.
Omusango gw'okubiri gwakuba muntu kyeke ng'okimanyi nti kyeke eyo njingirire kubanga tejja kukola ekyo kyenakola. Kigambibwa nti gwe ennaku z'omwezi zaali abiri mu mwezi gwa munaana omwaka mu Rwanga Zone Makindye Division mu Kampala District owa Basaji Robert kyeke namba not emu ssatu emu nga ya miliyoni 8 ng'agenda kutya ku akawunti namba 324994 ng'okimanyi bulungi nti kyeke gwali omuwadde yali temusobozesa kubeera ng'ajjayo sente ezo okusiira bulungi muweereddemu.
Have you understood the charge?
Mbiwulidde naye sibiyo bulungi.
Plea of not guilty is entered on count 2. For count 3, you're charged with issuing a false check contrary to section 358 of the Penal Code Act, Cap 128. You, Emmanuel Lwasa Kawes, also known as Lwasa Akram, on the 22nd day of August 2025, at Rwanga Zone, Makindye Division, Kampala District, without reasonable excuse, you issued Equity Bank check number 00131 for 4.2 million shillings to a one Wasaji Robert, drawn on account number 3200494914, without reasonable grounds to believe there were sufficient funds in the account to pay the amount specified on the check within the normal course of banking business.
Omusango namba 3 nagwa kwa muntu kyeke enjingirire mu kyeke njija kutumiza kigamba nti Lwasa Emmanuel Kawes Omugaga Lwasa Akram nakusomwezi nzali ali mu mwezi gwa munaana omwaka guno Rwanga Zone Makindye Division mu Kampala District. Wakimanya bulungi nti kyeke yali ya banka ya Equity yali namba emu ssatu emu yali eriko emiliyoni 4,200,000 nga kyeke eno wagiwa Basaji Robert agenda sente ku akawunti namba 32004994 okimanyi nti sente zino tezaaliyo ku akawunti eyo tesobola kuzifuna kaseera.
Have you understood the charge?
Mbiwulidde naye tebiriiyo.
Plea of not guilty is entered on count 3.
Koti ewandiise omusango ogusatu ogwegaanyi.
State.
Your inquiries are complete. You pray that the matter is fixed for hearing.
Wano gamantegeeza kkooti omunza ku musango mukwawedde asaba kkooti emuwa olunaku lw'okuweza omusango.
You have a right
Ssemateeka akuweddemba okusaba okweyimirirwa.
You object to his bail application.
Ssemateeka akubiriza okuddamu kwenya abaasabye.
I'm asking if you object to the bail application.
Owandiika okuddamu byagenda osaba.
Like you saw how we did with the first case. He would first present his application, we listen to it, then I'll listen to the state attorney, and then I'll listen to you.
Amateeka kingi asaba asooka n'asaba n'oddamu nga bwe gavumenti n'addamu okusaba kwoli kw'abagambye nawe n'okkirizibwa okubaako ky'oyogera ekyaba asabye.
Where are your sureties?
Abakweyimirira baliwa?
There is a contract between the court and the sureties and the accused person. Now, how do I enter into contract with someone I cannot see?
What is the proposal? Ekirala ko kyetegeeza nti okusaba okweyimirirwa kubakuteera olina abeeyimirira naye takulamuza batakulaba gyozibye amaaso. Photocopy of the nationality. What is the question?
I'm sorry, but I have issues with the Brazilian people. I'm a political figure.
There's nothing wrong with standing.
I don't know how I got that out of my constituents. I'm so sorry. I wasn't okay with it.
Okay, first and foremost, any person who has never appeared in court should be the first to cast a stone on any other person. There's nothing wrong with standing surety for anybody. Is it demeaning? Does it impact on your political career?
Somehow.
That you stood for somebody?
No. You know me, in my relationship with my husband, I've kept it on maybe all along.
Now you cannot keep it anymore because you see. It's not something that can happen. Let me take your name. What's your name?
Oh, so Maria. Yes?
Oh, Maria.
Oh, yes.
Florence. How old are you?
Yes.
How's good for you? Where do you do your business from?
kino bonaabona swate weebase.
We are not dealing with the merits of the case, we are dealing with the bail application. And if you're making your response limited to the bail application, why you think I should not?
Tekuli mu kubuliza musango oba kuwa bujulizi ku musango wabula ayagala oddemu lwaki kutwagala kooti empezi okweyimirirwa yadagala kyoboddamu kyokka sirya amasango gabunabundi
nti okumukwata kikibe kyembeerera kizibu nga nze kuba n'abasirikale bennyini boyinza ogaa nti oba bakwate Lwasa omu abanga mutya ekitiibwa omulamuzi badde nsaba omubeere wakisa oyimirirwa.
How do you respond to the issues that have been raised on your bail application? One of the sureties you have presented have challenged him on the basis that he's your employee and therefore cannot prevail over you to appear in court. And then the issues raised by the complainant.
oddamu mukiisobola kweyimiridde omukozi wo ayina okusobola kulagira kujja mukoza kyekyagala
nja kutwala obuvunanyizibwa nereete ate ndi mumanyifu nnyo sobola kubuulira wantu wonna.
Mr. Vice Mayor, apologies. I've been appeared before on the system. High Court's case. That's why I've come late. But I appear for the accused person who was I was there in the morning, I thought the judge should be the accused was going to be the charges in the morning. Unfortunately, but I'm told you are applying for me. Yes. And I prepared the sureties you are as the introduced in yes, that's what I'm saying, but I prepared them before I left. Yes,
My ruling cannot in any way prejudice or put a stop over a possible settlement. So whichever the outcome, settlement can still be pursued. This is the ruling of court. I have carefully considered this application as presented by the applicant. I've also considered the objections of state and the reservations raised by the complainant. I've also considered the sureties that have been presented by the applicant. It is important for all of us to note that applications for bail are premised on presumption of innocence. Bottom line. Applicant before me also enjoys the same presumption. The rationale for these constitutional guarantees is to ensure that innocent people are not kept in prison for nothing. Therefore, our constitution put in place safeguards to ensure that people's rights are not abused, bearing in mind the period taken by courts to resolve these matters, only for one to later turn out innocent. Bail is surely a bitter pill for prosecution and complainants, but again it is a cornerstone justice system. Person is opposed to it must learn to live with it, because one or the other, they will also be beneficiaries of the same system. And then a case being released does not in any way guarantee acquittal. In the same vein, the applicant before me should be looked at in the same lenses of innocence. It is only then that court can adequately dispose of applications like this one, and let alone the formal trial. Applicant has presented two sureties. One of the sureties is his wife, while the other is with his driver. State raised concerns over his driver that he cannot prevail over the applicant, which view I also share. I don't find a driver of a person a convincing surety. How can a driver prevail over his principal? I ask. On that basis, I reject surety number 2 because he is not substantial. However, I already presented his spouse, who is not contested, who I find substantial. She's more compelling and can prevail over the accused in this matter and compel him to appear in court whenever required. I have concerned myself with the complaints raised by the complainant, but again, they are not substantiated. Inasmuch as he claims that police fears the applicant, it is the same police that investigated this matter and presented the applicant before court. If indeed police was afraid of the applicant, this matter would have never seen the light of day in court. Such arguments cannot be left to stand. All in all, the applicant has satisfied the condition for the grant of bail. His application is allowed. He will execute a non-cash bond of 40 million. His one surety, who is his wife, is bound in the sums of 30 million, not cash. The implication of these non-cash bonds should be emphasized, that in the event of absconding, then the applicant would be arrested and would only be released upon payment or upon executing these recognizances. It should therefore sound a warning to the applicant that he must present himself before the court whenever it is required in order to fast-track the process. Bail is granted in the terms suggested by the court. We will report back here on the 8th of January 2026 when this case shall appear for hearing. Should reconciliation take root, parties should notify the court so that it can give further orders and directions in this matter.
Omwana gavumenti yazzeemu tunoonye yawaaba emisana gazzeemu koti mutusaba okweyeeba tutunuulira ebintu bingi ekimu kyo nti omuntu okulusomera emisango ateeza nti emisango yaguzza kimala kwetaguliza okukasa ensonga eyaguze agamba nti yalesa bamulimiire ababiri nze akanyolera oluwaabi abadde ayogera owokubiri si wankizo okweyimira mu muntu ono kubanga bwevaawo tasobola kumulagira kujja mu kooti abeera mukozi we asolagamba mukama we abeere nga tumukooti nagamba nti ayeeowokubiri tasaana kweyimirwa amirwa kitegeeza asigaza amulimirwa omwo mukyala we kootiyeye wankizo asobola okukumiza okubeera nga tumukooti kooti nemukiriza okweyimirwa kaluka kooti amiliyoni 8 ezitali zabulwo nyamuyimiridde mukyala we miliyoni 3 ezitali zabulwo kumugamba sente ziragamba ezitali zabulwo zikukoleza kusinga takomyewo mu kooti enakuera kooti emitegeeza okukooti nagamba tafuna mwezi 8 omwezi ogusooka nesinga abawo ebigalala zonna bamutuuseeko ngerategeeza kooti namutuuseeko.
The son is
Carry on. Suspect.
Name.
Together,
Ross. Ross. People want